On February 27, 2013, the Supreme Court of Canada handed down its decision in the Saskatchewan Human Rights Commission versus Whatcott. This landmark decision on hate speech has implications for the freedom of expression of all Canadians, and for Christians in particular. Here is ARPA's legal counsel, Andre Schutten, to explain.
Yesterday's decision had both good and bad elements. Some of the positive elements in the decision include the Supreme Court's concentrated effort in reining in the definition of hate speech. No longer is just offensive statements allowed. Rather, they made a much tighter definition of hate and raised it to a higher level. Another positive is that the Supreme Court specifically mentioned that Bible texts are not to be considered hate speech. This is especially noteworthy because during the oral testimony at the Supreme Court, a lawyer with the Saskatchewan Human Rights Commission actually made the submission that some Bible texts could be considered hate speech. Some of the negative implications from this case, though, outweigh the positive. For example, intent is not relevant. The court said that intent to produce hate speech is irrelevant in the decision on whether or not speech constitutes hate speech. Another blow to free speech came in paragraph 140. The court stated that truth is not a defense to a charge of hate speech. This is particularly troubling. How can we justify prosecution of the truth? Another blow to free speech was when the court said that no proof of measurable harm is necessary to prove hate. This too is troublesome. How can we prosecute people for hate speech when we haven't proved that there's any harm? So what does this ruling mean for everyday Canadians? What does this ruling mean for Christians? Well, first of all, with the hate speech provisions remaining in law, there remains this possibility of a shakedown, where somebody who's offended by something that's said from a Christian perspective or from any perspective can still bring a complaint to a Human Rights Commission. And there remains that possibility of a threat to deal with that sort of process. This creates a chill on free expression in Canada. People are less likely to engage in public policy debate because of this threat that remains over their heads. Another issue that this case raises is that it's going to be much harder to lobby for real change at the provincial legislatures on hate speech provisions. I think that provincial legislatures are going to be happy to accommodate this new ruling, but won't go any further. It's going to be our job to engage with the provincial legislatures to remove censorship provisions. Now, interestingly, the Supreme Court actually left that open to us. Tucked away in paragraph 104, Justice Rothstein says this: "I do not say that the marketplace of ideas may not be a reasonable alternative. And where a legislature is so minded, it will not enact hate speech legislation." What he's saying there is that there's a number of different reasonable alternatives that a legislature may use to combat hate speech. One alternative is very strict hate speech laws. Another alternative that he says here is that idea of the marketplace of ideas, where there's no restrictions on what is said, but rather competing ideas in a marketplace of ideas can tussle and wrestle and come out on top. Now, the Supreme Court also does not allow, in this decision, does not allow for the distinction between sexual identity and sexual behavior. They said this, paragraph 124, quoting, "If expression targeting certain sexual behavior is framed in such a way as to expose persons of an identifiable sexual orientation to what is objectively viewed as detestation and vilification, it cannot be said that such speech only targets the behavior." End quote. Now, this is somewhat troubling in that it runs contrary to a confessional understanding of sexuality and of human depravity. This rule now makes sexual conduct more difficult to critique as separate from a person. Christians will have to be much more careful in how they go about discussing sexual ethics. Now, here's a fun bit of irony. The Supreme Court emphasized that the intention of the person distributing so-called hate speech does not matter. That's irrelevant. They said the only thing that's relevant is the effect of the hate speech on the target group. Now, if that is true, then here I have the Supreme Court's decision in this case. And if you look at the back, they've actually attached the 4 flyers that Mr. Whatcott distributed. Now the Supreme Court has distributed the exact same hate speech that Mr. Whatcott distributed. And since the intention of the person distributing does not matter, the court said so itself, it's irrelevant, then now the Supreme Court is guilty of distribution of hate speech. That's how ridiculous this idea is. Surely the 6 judges that wrote this decision shouldn't be charged with hate speech. Or should they? Now perhaps the most meaningful line in the entire judgment, I think, is paragraph 48, the opening sentence. There the court says this, quote, "A prohibition of hate speech will not eliminate the emotion of hatred from the human experience." End quote. This is sad, but true, and so biblical. The reality of a fallen world is that hatred will always exist until the end. Only the preaching of the gospel can reduce the incidence of hatred, and only the final return of Jesus Christ will end all hatred. In this sense, hate speech provisions are somewhat misguided. So Christians, now is the time to act. Now is the time to move forward. Freedom is best protected when it is exercised, and so speak up, speak out, and do so, exemplifying the love and the truth and the grace of our Lord Jesus Christ. When we speak the truth in love, we can win by God's grace. Thank you very much, and all the best in the fight for freedom.